welcome, lovely people, friends and colleagues, students, to our videos on criminal law in Ghana. I'm sure you've watched much of the other discussions that we've had on criminal law, from the introductory video where we spoke about the introductory video on criminal law, what we discussed as crime, the elements of crime. I'm sure you'll be following into the series. Let me mention to you and repeat that this particular series of videos are more academically inclined. That is for those persons who are interested in studying the law as an academic subject, or they are studying criminal law as they do in their various faculties, or probably for those who just need a brush up on criminal law you are going through Ghana School of Law and you are doing probably criminal procedure. This video is designed to support such kinds of studies. So realize that there's a lot of emphasis on case law and a lot of legal reasoning in the analysis that we do here. But however, if your interest is just to understand the criminal law, or other aspects of the law for everyday use, I entreat you to always pay attention to the everyday law part that also comes up on our YouTube channel. So when you go to our YouTube channel, you see everyday law. That one is more for the everyday man, the layman, the person who is not interested in learning the law like a lawyer or like a prospective lawyer. But if you are interested in still wanting to know more in depth, then this set of videos is for you. Hope you're okay. All right, so with that said, what are we going to discuss in this video? Okay, in this video, we are going to focus on the offense of robbery. The offense of robbery. What is robbery? What does the statute say? What does the law on robbery what has it got to say? That is what is going to be the principal focus of us in this particular video. Okay, so we've mentioned robbery. Now, when you take the Criminal Offences Act, Act 29, okay, and like I said, the Act 29 specifies much of the criminal offences at the time Ghana became a republic. So the Criminal Offences Act 1960, the time that was enacted, Act 29. In there, it explains under a classification of offences, which we call crimes of dishonesty. Okay, crimes of dishonesty. When we say crimes of dishonesty, it simply means that those aspects of crimes that have got to do with dishonest conduct, that a person acts in a way that doesn't show that he's being truthful and showing respect for the properties and rights of others. So under the large umbrella of crimes of dishonesty, you'll find stealing, dishonest appropriation, etc. So robbery forms part of the classification of crimes that we call crimes of dishonesty. So what is robbery? What is robbery? All right, I'll take you again to the Criminal Offences Act, Act 29, Section 150. It explains what robbery is. Let's look at the Criminal Offences Act 29, Section 150. Section 150, definition of robbery. A person who steals a thing commits robbery. A, if in and for the purpose of stealing the thing, that person uses force or causes harm to any other person, or if that person uses a threat or a criminal assault or harm to any other person with the intent to prevent or overcome the resistance of the other person to the stealing of the thing. So Section 150 there for you, as you saw. What does it say about robbery? It says that if a person, okay, tries to steal an item from another person, and in the course of an attempt to steal the item, he uses force, a threat of harm, such that the intention of the use of force or threat of harm is to prevent the person or the victim from trying to challenge him, or it is with the intent of overcoming the victim, such that he can take the thing away, we say that it constitutes what? Robbery. Hope you are clear on that. It's very simple. So there's an element of stealing, okay? There's an element of use, there's an element of the use of force or the threat of harm with the purpose of overcoming the particular individual. This is in summary what basically we mean by what? Robbery. Okay, so now it is important to understand. Later, you may see in other videos, if you've not watched it, you may look for it on our discussion on stealing. All right, so stealing, just in brief, just to reiterate, is that stealing is the act of trying to dishonestly appropriate a person's property or appropriate a property to oneself when the person knows that he is not the owner. Okay, so if you take someone's item or use it or deprive the person the use of that particular item, in the sense that you know that you are not the owner, that constitutes stealing. So now robbery comes in and says that, all right, in your course of trying to do that particular activity, in your course of trying to prevent the person, the real owner, from the use, you attach force, you attach a threat of harm, you attach criminal assault. And that intention is that you overcome that kind of resistance that the person may be able to put up against you. We are saying that that action constitutes robbery. All right, so that is section 150. Now, I'll come back to it later and we'll do further analysis and we'll use some other examples to explain it further. But I again want to take you to the Act 646. Now, Act 646 is the amendments that came in 2003 to the Criminal Offences Act. And under section 149 of the amended Criminal Act, Act 29, that is the Act 646, the amended one, it gives us some other additions that we want to just look at it, then we'll put up together. We'll have a very nice discussion in there. All right, so let's go to the amended Act of Act 646. That's the Criminal Amended Act of the Criminal Offences Amendments Act 2003, Act 646, and look at section 149. Let's see. Section 149, subsection 1. It mentions, whoever commits robbery is guilty of an offence and shall be liable upon conviction, on trial summarily, or on indictment, to imprisonment for a term of not less than 10 years, and where the offence is committed by the use of an offensive weapon or offensive missile, the offender shall, upon conviction, be liable to imprisonment for a term of not less than 15 years. Subsection 3 continues. In this section, offensive weapon means any article made or adapted for use to cause injury to the person or damage to property, or intended by the person who has the weapon to use it to cause injury or damage. And offensive missile includes a stone, brick, or any article or anything likely to cause harm, damage, or injury if thrown. Did you notice what was said in the section 149, the amended act, the amended version of the Criminal Offences Act? All right, did you see that? It mentions that if the person who commits a robbery, and again, we've already seen the definition of robbery. If the person commits robbery, and in the act of robbery or in the robbery, he used an offensive weapon, okay, an offensive weapon, an offensive missile, then there's some bit of extension, or there's some bit of a wider punishment that will be prescribed on him. Now, the interest for us is that when you look at the section 3, it mentions that when we say an offensive weapon, okay, an offensive weapon is that kind of weapon, okay, any item that a person has been made for such purpose, or it has been designed or adapted such that it is likely to cause injury or it can cause a person harm. It constitutes an offensive weapon. And it also mentions that when you say an offensive missile is any article that when you throw, it is likely to cause harm or damage to somebody. So the statute mentions, for example, a stone, a brick, and anything of such sort. All right. So guys, the point is this. If you put together the ideas of section 150 that defines robbery, and you put together what we have under section 149, the amended version, the amendment of the Criminal Offences Act, we can therefore see that when we say robbery is when there is an attempt, or when you steal, when a person tries, okay, or steals another person's item, and in the course of that stealing process, he uses a threat of harm, criminal assault, or uses force to overcome. And that force may also include the use of offensive weapons. Okay. So if, for example, someone is driving his car, or someone has a car, he's sitting in his car, probably in the evening, he's going to buy something at a shop, a mall, or something like that. Probably checking on his phone. And a person just walks towards him. An unknown figure, an unknown man walks towards him, probably clad in some face masks. He goes and knocks on the window. Then the person raises up his head and turns to see who is at the window. Now he realizes that the person has got a gun pulled at him. Okay? So what does he do? Out of panic, he just rolls down the window or opens the door. He snatches his phone and he leaves. What has he done? He has stolen the item from him. But remember, he did that because the gun that he pointed to the victim, it disabled the victim from attempting to resist that particular attack. You understand that? So that would constitute robbery. So for the offensive items, it could be, and when you look at the case law, it mentions a lot. You would see a lot of them. It could be anything. It could be a knife. Okay, it could be a knife, a kitchen knife, dagger, machete, cutlass. You know, sometimes people use those things. Stones, bricks. It could be wooden planks. Wooden planks. Sometimes old wooden planks. It happens. You would see something. Even a bottle of acid, a bottle purported to be acid. It can constitute an article that can be used in dispossessing a person of a property, and that in itself also constitutes robbery. You understand that? So if someone comes up to you and he has, for example, an acid in a syringe, okay, and he points it to him, points it to you and said, okay, look, do this, and he wants to take something from you, and you have reason to believe that what is there is actually a very corrosive substance that can cause you harm, and out of that fear, the person is able to dispossess you. We say that it is robbery. That is it. All right. So now that we have a clear idea of what robbery is, okay, and the kind of elements that are in there per the statute, we'll now try and move on and discuss some particular case law, some case laws that some judicial pronouncements that have been made in the courts, and see how that also adds up in there. So to this juncture, I just want to mention that if you're a student of law, and for example, you in your exams, a question comes and it's on robbery, okay, you are being tested on robbery, or probably you're preparing for the Ghana School of Law entrance exam, and you are probably looking at a case where maybe you'll be tested on robbery and what are the elements are there. What you need to do is that you need to understand the rules. What are the rules? What does 150 say? You need to be conversant with what section 150 mentions, that the threat of harm or criminal assault with the aim or intent of trying to overpower the person, said that disable the person from actually mounting resistance. You need to understand that. Then you also need to take cognizance of the Act 646, the amended one, that mentions what will constitute an offensive weapon. So those kind of things, those kind of articles there will help you to know, because sometimes maybe you read the facts of the case and the use of a gun, the common items that are used for robbery, guns, knives, may not necessarily be in the question. Okay, but the point is that the statute mentions that if there is any particular article, that article in its natural use may not be used for robbery, but it has been adapted for such purpose, it could constitute robbery. You get that? It could constitute an offensive weapon. Why? Because it has been adapted. You have changed its normal use and modified it in such a way that you now intend to use it in a manner that can inflict damage, and therefore the fear of the damage will cause the victim to avoid mounting resistance, and that allows the attacker to dispossess him. All right, so that is what we mean by robbery in there. So for the students, just take note of that. Now we'll go to a very famous case. You know that case. I mean, if you talk about one of the most phenomenal, sound judgments that has ever been given in the 21st century Supreme Court of Ghana, and the greatest contribution to Ghana's criminal jurisprudence, you cannot take away this case. And the case is Kweku Frimpong, alias Igbo Man versus the Republic, reported in the 2008, 12 Supreme Court of Ghana law reports. And it was obviously delivered by one of Ghana's most venerable and stunning judges when it comes to criminal law, Justice Jones Victor Maulum Dochi. So, Kweku Frimpong, alias Igbo Man and the Republic. Remember that case? All right, if you don't, let me just give you a brief facts of the case. Now, Frimpong, Igbo Man, Kweku Frimpong, he hails from Domiabra, somewhere in Konongo. All right, so he was working, according to the facts of the case, he used to sell some second-hand clothes, what they call folks, around Kantamanto area. So some of his friends actually told him that, look, Charlie, there's some kind of job, that operation that they want to do. Okay, so they took him to somewhere, I think, Oyarifa, all right, because apparently some of his friends had also done some checks, and they knew what they were going to do. There was the attempt was going to steal from a certain man and his family who lived in Oyarifa. So they took Kweku Frimpong and he joined the gang and he went there to conduct the operation. So when they got to the house, some of his friends also bunched into the man's house, the occupant of the house, subjected them to various forms of beating with all kinds of implements and assaults. They assaulted them. You know, as we are just mentioning the Section 150, it was of such a nature that the people couldn't mount any resistance. Then they took away from the man a BMW. Now, all this while, when this robbery was going on, Kweku Frimpong was part of the team. He actually his task in the role of the robbery operation was to stand at the gate, what people call, say, Obebalangad. Okay, so he was at the gate, just being on the lookout to make sure that there is going to be a tip-off, a policeman is going to come and all that. So he was part of the robbery gang. So when they finished the robbery, all the booty that they stole from the man's house, they robbed the whole family, picked up several items, phones, cash, watches, jewelry, etc. They put it in the BMW, and Kwaku Frimpong was the person who was tasked to drive this BMW right away from Accra, and he went to hit the BMW in his village around Domiabra, near Konongo, in the Ashanti region of Ghana. So through police intelligence and a lot of investigative acumen demonstrated by the police, eventually Kwaku Frimpong, alias Ibuman, was arrested, brought before trial. He was found guilty of robbery, conspiracy to commit robbery, and he was sentenced to 65 years in prison. So he decided to mount an appeal, and it was at the Supreme Court that Justice Duchi set out in clear, uncontroversial, unambiguous terms the elements of robbery, and it was a very stunning piece. Let's look at what Justice Victor Jones Maulu Duchi said in the Frimpong alias Ibuman case on the elements of robbery. By Justice Duchi, by court, to prove the offense of robbery, the prosecution must establish the following. I, that the accused has stolen something from the victim of the robbery. In stealing the thing, the accused had used force, harm, or threats of any criminal assault on the victim. I. The intention of doing so was to prevent or overcome any resistance. IV. The fear of violence must be either of a personal violation to the person robbed or to any member of his household or family in a restrictive sense. And V. The theft must have been in the presence of the person threatened. In the instant case, where it was the appellant who had kept guard outside while his accomplices used threat to procure the stolen items and the keys to the BMW car, which he drove away and kept, he was much as guilty of the offense as those who had used the threat, because it was he who had facilitated the committing of the offense and their exit from the scene. Did you notice that outline given by the court, which was speaking to Justice Jones Duchi in the Frimpong alias Ibuman case? So that is it. You will realize that the points that were set out in here as to the elements of robbery is consistent with what the statute says. The significant part that you need to understand and notice that when we mention the robbery, the fear of violence may not necessarily have to be visited against the victim himself. Okay, if it is brought against another member of the family of the particular victim, okay, that one is also constitutes part of we see that the threat of the violence. So if an accused person went, okay, and let's say if the attacker went there and he pulled a gun to somebody, okay, which was not actually, maybe he pulled a gun to the victim, and the victim to which the gun was pointed was not the one that probably items were taken from. I mean, it doesn't actually make any difference. And that was why we are saying that the court found that Kwaku Frimpong couldn't actually absolve himself from the idea of the robbery. Why? Because he kept guard outside. He kept guard outside. When they stole everything and gave the keys of the BMW, he was the one who made sure that he facilitated their exit from the scene, just as the court has said. So perhaps, even if the family might have looked out of the window and saw that there was a possibility of escaping, the presence of Kwaku Frimpong actually wouldn't have given them any motivation to attempt to escape. Why? Because there's a kind of a watchman there, a person who's on the lookout, watching out for the criminal gang. And the court actually still upheld the decision of the trial court and the Court of Appeal to find him guilty of robbery. So that sets us the elements of robbery, as you will see. All right. Now, to throw further more light on what we are seeing, these elements of robbery, it has also been restated in several cases. We'll take one more case, then we'll bring the subject of robbery to a closure. In the very recent Supreme Court case in 2021, okay, the case of Kingsley Amankwa, aka Spider versus the Republic, okay, another famous judgment that was also delivered by His Lordship Justice Victor Jones Duchi in that Kingsley Amankwa alias Spider's case versus the Republic. And in fact, when you read that Kingsley Amankwa alias Spider's case, the Supreme Court made a lot of references to the Frimpong and Ibuman case. Justice Oche made reference to those things, those elements that were set out in there. You will also find out that they were also being replayed in the Spider versus the Republic case. Now, a mix of the Spider case of the Republic, okay, he was in company with his 3 friends, okay. He was reputed to be a very good guy, a very good footballer, as the facts admit. Then around 1 a.m., somewhere around Odoko, they visited a family. I mean, the family had a lecturer and his wife and their 1-year-old baby girl, then the lecturer's father. When they went there, said around 1 a.m., according to the story, they heard that there were some loud and violent bangs on the door from their kitchen. When they just woke up, they saw that about 6 men had bumped into their kitchen. They came to the kitchen door and entered into the room. Now, when they entered into the room, one of them pulled a gun at the 1-year-old daughter of the lecturer, okay, and directed that they should bring out all the money that they had on him. So the wife was scared, and eventually they succeeded in taking all the items out. So what happened was that after this particular action, one of the mobile phones, so just a Nokia phone, one of the mobile phones that was missing, okay, the wife of the victim, like the lecturer's wife, told the police that along the line she received a text message, and the text message was a text message that she saw that it was the husband who had sent the text message, and she was bold enough. She later used her phone and called the number and pretended that she wanted to be friends with this person who had the phone. And the guy also stupidly also decided to set up communications with the wife. Eventually, the wife reported the matter to the police, and the police laid an ambush. So when the guy came there to talk to the wife, apparently he thought that he had a new girlfriend. The police just came and arrested him. It was through this that he eventually arrested Spider, because it was Spider who had sold the phone to the guy, the other person, he was called Kobina, who had now gone to meet the wife. When the matter was brought to court, the police, before the matter came to court, the police did some kind of arrest, and the husband came there, okay. When the husband came, he went through the list of persons, and he clearly identified the appellant. He saw that this was Spider. He said, I know this guy. But you know, when they came there, it was not Spider who pointed the gun at the daughter, actually. But Spider also entered into the room. Okay, so this was what the Supreme Court, in the case of Spider versus the Republic, again, Justice Uche trying to strike the correlation between the Igbo man case that I have already explained a bit of the facts to you earlier, and this is what they said in the Spider case versus the Republic. Let's see Victor Uche speaking for the Supreme Court. By parity of reasoning, we are of the considered opinion that in the instant case, all the above ingredients had been proved against the appellant. This is because the appellant and his criminal gang has stolen the items listed in the charge sheet, supra, from the residence of the complainant. It was one of the items stolen, the Nokia N70, which they sold, that blew their cover in this criminal conduct. In stealing the items, there is abundant evidence that they used violence, reference the shooting of PW3, and the threatening the 1-year baby girl with a gun, and other acts of violence recounted elsewhere in this rendition. The intention of doing so was to prevent or overcome any violence. The fear of the violence was actually not only to the complainant and his wife, PW2, but to the entire household or family. And finally, the theft was in the presence of the complainants and the others. Good. So did you see that? The Supreme Court in Kingsley Amankwa, alias Spider versus the Republic. Again, they saw the correlation, and that is, you notice the clause that was, the phrase that was used, say that by parity of reasoning. And the court went ahead to outline the same modus operandi and principles that were there. So there's a stealing act, there's a use of threats of criminal assault, and this threat of criminal assault is not just directed towards the victim, but to the victim's household. And if all those elements are there, robbery is said to be proven. So Kingsley Amankwa's conviction was upheld by the Supreme Court, and he is still languishing in prison, hoping that maybe when he has made his time, he will come back and join society as a rather right-thinking person. So guys, that is what we mean by robbery. That is what we mean by robbery. Section 150 outlines it. 149, the amended version, mentions the use of offensive weapon and what could constitute an offensive weapon. Articles that are made or designed to be harmful, to cause damage, or articles that are adapted to cause that kind of injury. And the various cases that we've examined, the Kwaku Frimpong alias Igbo Man case versus the Republic, and Kingsley Amankwa alias Spider versus the Republic 2021, all illustrates all these points. There's a stealing of an item, there is a use of harm against, a threat of harm or force against the victim or a member of the household, and all those attacks have also happened in the presence of that, and actually items have been stolen. These are the constituents and ingredients of robbery. So again, if you're a student and you are answering any questions in your exam on robbery, try and understand how you're going to use the rules, and try and see how best you can also do the applications. That is it for the offense of robbery. Stay tuned in our subsequent videos as we discuss more of the crimes of dishonesty.